where several of us contributed to looking at what is happening in policy across different countries in the global south. And this publication is available, so you can take a look at it and send us your comments on it also. I'm sure that several of you have participated in some of the consultations that India has also had on its national legislation, and we would like to hear from you about how those processes are shaping. So let's go ahead now with also looking at what is happening in the UNFCCC process and where this whole idea of carbon markets has generated. It is Article 6 of the Paris Agreement. Some of its features are being looked at right now at COP30 as we speak. And we have Mr. Jonathan Crook, who is part of the Carbon Market Watch, who has kindly shared this video with us about what's happening with Article 6 and what are the national legislation processes shaping up. So let's take a look.
Hi, I'd like to thank the organizers for inviting me to record this presentation today. My name is Jonathan Crook. I work at Carbon Market Watch, which is a Brussels-based NGO that works on carbon pricing. And so, go ahead and restarted. So I think you may already be familiar with Article 6 carbon markets, so I'll just go on this rather briefly. But Article 6.2 is effectively a very loose framework through which countries can effectively actually do carbon accounting under the Paris Agreement. Because the Paris Agreement requires that all countries have climate targets, it means that there can't be double counting between two different countries counting the same mitigation, or a country and a company, or a country and an airline counting the same mitigation. So actually, in many ways, Article 6.2 is a framework to do the accounting under the Paris Agreement. Through Article 6.2, where they give their formal government authorization and their approval. The issue with Article 6.2 is that it's a very loose framework, and that governments can really agree on most of the rules regarding the underlying carbon credits. So there are unilateral arrangements, but it's very loose and very decentralized. Article 6.4, on the other hand, this is the carbon crediting market that kind of effectively replaces the clean development mechanism from the Kyoto Protocol. And this is a much more of a centralized system with more direct governance. And this will actually set up carbon crediting methodologies so that project developers can apply to be underneath the supervisory body, the rules of the supervisory body, and will actually generate carbon credits under Article 6.4. When Article 6.4 credits are authorized by a country, they actually go into the 6.2 system, but that's maybe a bit more nuanced than we need to go into today. Effectively, 6.2 is a very decentralized framework where if a government agrees to something, it will be counted as a carbon credit that's eligible in most cases, whereas Article 6.4, there is more oversight and governance regarding that process there. For a quick recap of the timeline on Article 6, so after a few years of implementation, how is Article 6 working? Do rules need to be checked or changed? That sort of thing. When you look at, this is a WRI, which has a tool that tracks kind of NDCs, many different aspects of them, and this is whether countries plan to use Article 6 in their NDCs, whether they declare that they will use Article 6. And as you can see here, a lot of countries, a lot of parties, Paris agreements, and say that yes, they may use it. The no right there is for the EU, or it's one of the more prominent ones. That actually, as you might be following, might change right now, which we see as a big problem because it's substituting domestic mitigation in the EU. It will do that, and that's how it's been negotiated, in fact, at the moment. But that process isn't done yet. And so what you see here is that there's a lot of countries that might use Article 6. This doesn't mean all of them, all the ones here, will actually use it. NDCs are intentionally quite vague, and there's just one kind of cell in the table for Article 6. So, and in most cases, it's really not detailed very much. So this is not to say that all these countries will trade credits under Article 6, but they're keeping. There are some here that are for sure going to Switzerland, Japan, and South Korea are some of the most prominent ones that are kind of transacting credits, but there are others as well who might arise. So indeed, the Article 6.2 framework in particular is very, very weak. So we wrote a report about this in July, assessing the rules against different quality criteria, and found that in Article 6.2 it performs very poorly, and that's because, as I mentioned, there's very few rules there. It's mostly up to countries to determine what is good quality in terms of what they want to trade. And so here we see a lot of problems. I won't go into all the details here, but I think one point that's worth calling out is, in terms of equity, there are no real meaningful social safeguards in place. There aren't kind of minimum standards for how benefits from a project should be shared with those involved in it. There isn't a centralized grievance mechanism in case there are problems that arise. And the UN review process that reviews Article 6.2 reports does not have a very strong mandate. So this does not give us confidence that Article 6.2 will be a strong framework, in particular on many issues, but including on safeguards and human rights, which, even though it's enshrined there that there should be respect for human rights, it's a very high-level principle, and there's not a lot of details to actually ensure that that would happen. And we're starting to see problems. So there's been different, so Alliance Sud, which you can see on the left here, has done several investigations into some of the projects that Switzerland is planning to do, and in this case, they looked at one case here of a coke stove agreement, and found that there was redacted information, and that when they got the full information, after it wasn't redacted anymore, they had to request this information. They found that there was arbitrary decisions that would artificially increase the crediting by a huge percentage, about 80%, for no discernible good reason. In fact, it was going against the rules of another Swiss body there. So that's just an example of some of the things that are going wrong. There's also been cases of, we see also different approaches. So there's other approaches regarding avoided deforestation, which are very controversial because they can generate a huge amount of credits, but have been shown in many cases in the past to not be reliable. In Guyana, for instance, this is one of the approaches. They use a very controversial carbon crediting approach, which brings about many risks. And there's also been allegations that there wasn't appropriate free, prior, and informed consent in that context. Suriname as well is trying to turn red results from Article 5 of the Paris Agreement, which is not a carbon crediting standard. They would like to turn those into ITMOs under Article 6, which would be very problematic because these lack the proper integrity. And we also see problems regarding safeguards in place, and so we see, for instance, there was a firm in the UAE called Blue Carbon, which was starting to sign MOUs with many countries, including many countries in sub-Saharan Africa, that were very troublesome, very concerning. So they signed deals, to MOUs. It doesn't necessarily mean that deals will come with that, but MOUs that covered for Liberia a tenth of the landmass, 20% of the landmass of Zimbabwe, and large swaths in Kenya, Zambia, and Tanzania as well. And this is part of the problem, is that, if, for instance, if some of these MOUs become firm deals and go ahead, and those governments agree to it, there's very little that can be done. So if safeguards aren't being upheld, if the quality of credits is low, there's really not much that can be done, which is a real problem. When it comes to rights and safeguards in Article 6.4, so in Article 6.4, there is a sustainable development tool, as it's called, and this is actually a document that's listing safeguards that need to be in place there. And there are some positive elements there. So, for instance, there are some principles that need to be followed regardless of national legislation or rules. And that's, for instance, the Universal Declaration of Human Rights. That's positive because we know in different national contexts that might or may not have, be recognized. So that's a good principle. But there are also shortcomings. So, for instance, free, prior, and informed consent, which is a critical, it's critical in carbon markets when people are involved on the ground. So this is required when indigenous peoples are concerned, but it's not required for local stakeholders or local communities. And part of the problem here is actually that in many country contexts, indigenous peoples are not necessarily recognized by their national governments or regional governments. So that means that if they're not designated as an indigenous peoples group by the government, it would mean that this rule for free, prior, and informed consent might not actually apply in that case. So that's a big shortcoming in the rules there. Similarly, the supervisory body, their tool, it encourages that project developers should not involuntarily resettle people, but it does not actually forbid or ban that from happening. So that's a pretty glaring problem in the rules there. And then finally, one other development which is quite concerning is that they've been discussing whether or not they would have deviations from these safeguards. So effectively, they're saying if there are unavoidable negative impacts, which are undefined at this stage, that perhaps there can be deviations from applying safeguards. That's obviously a huge concern to us and to many other NGOs because deviations from applying human rights safeguards or free, prior, and informed consent or other factors would be a real problem. And right now, it's not clear what this would cover. So we don't think this should happen at all. But at the moment, there is ongoing work to better define these criteria. But the risk we see is that this can be highly subjective and lead to quite poor outcomes. And so, as I mentioned, with Article 6 being implemented, it's important to note that the country where the mitigation...
So this is, we have very less time. So just as an overview of what is happening at the international level in terms of the agreements that India has signed, where there is a process of diluting safeguards. And while then it becomes important for nation states like ours to have safeguards within our carbon policy. So just to go back, we do have three really special panelists with us who spoke to us, including Anjali, who has done a very comprehensive review of India's legislation and how it is developing. So before we come to you, Anjali, we will look at the other two panelists. We have Ms. Elizabeth Mesconte from Kenya. And she belongs to an organization called Impact, which is actually working with the pastoralists in Kenya who have been dealing with the effects of carbon markets developing and carbon credits being developed on their land. So we asked her a few basic questions. We asked her to talk about a little bit more about the climate change, carbon market regulations of 2024. Just last year, this was done in Kenya, and it is based on the Climate Change Act that Kenya has enacted. And we wanted to also ask her what is the linkage between this regulation and the existing laws that are looking at communal use of land, communal ownership of land. And this is a very similar case because we have the same constitutional structure in India. We also have the Forest Rights Act, which is absolutely not being taken into consideration while developing our legislation. So this is a great sort of learning process for India. They also, within this regulation, there is a specific mechanism called the Community Development Agreement. What is this agreement? Is something that she shared with us, and is it actually beneficial for communities? And we also wanted to know what are the grievance redressal mechanisms that are present under this law. So we just look at what Elizabeth had to say. I'm sorry for the disruptions, but this is the best we will do for this particular event.
The Climate Change Act, the 878A, which talk about climate change, environment, and how the country is supposed to maneuver around those issues. And now they have, after the regulations, the Climate Change Carbon Market Regulations 2024, they incorporated the issue on carbon markets and carbon credits. And how does it relate with other land laws? As a country, we have the Kenyan Constitutions, 2010. We have the Community Land Act, 2016, which part of it is how community lands should exist, or how are we going to transit from the former group ranches or the former trust land to community lands. The idea was to give these communities a right to own, use and access those resources in a legal way, if I can call it that, or in a recognized way. They have been living in this communal land where they live communally, so the land is for everyone. But recognizing that land is for them, or that certain territory is for a certain community, gives them a right to access or use all the resources in that land, which among them is the carbon credit as a resource. So the regulation, yes, they have given communities some rights, if I can call them some, because it's not all the right. I'm calling it that because the document is complex. Really, you can't give to grassroots people or grassroots communities to read that document and understand. It's not that simple for communities to understand. So yes, as much as we have these laws, they are documented, the regulations are there. It has given communities a certain percent, which is 40% for the land-based project and 25% for the non-land-based project. But how are we going to trickle down this information to the communities, for communities to really understand, to really get the information, to understand what is the type of carbon, are the terms that are being used in those documents, because most of these documents are legal documents, which the terms are really difficult even for the learned people, but how are communities going to understand that we have what we call a common a carbon registry, we have the communities agreements, we have the national determinants contribution, which is the Paris Agreement. That the contributions will be incorporated in this document, and they can be heard and they feel they are part of with as we stand, some even don't know the types of carbon markets that exist there. So yes, we have the regulations. It's a good document as a country. It has placed communities in a good level because 40% is a good start. But the question still remains: is this information trickling down to the communities, or are the brokers taking advantage of the available knowledge? At the aspect of the communities. So that is what I can say. Yes, the couple of regulations talk of community agreement. And yes, it's very useful because one, it's legally recognized, so no entity can go to the community without those CDS. And that gives a community a platform to really be involved in those issues. But again, the questions comes in, does these communities have a capacity to develop these agreements? Yes, the regulation gives a directives of who should be involved in developing those CDS, community development agreement, which will have an expert in many field, which environment, the energy sector, the community, the government representatives, and all those bodies that are involved in the environment sector. So the communities will get a chance, yes, to develop those agreements. But are these communities able to really maneuver around the terms on agreement? Yes and no at the same time. They might have the capacity to say what should be included in those agreements, and they might not have the capacity. And where they lack the capacity, and maybe the person or the project proponent bringing the project is not a straight person, if I may call it that, they might take advantage of the communities and manipulate the agreement to their advantage. But when the communities have a capacity for those developing those agreements, then yes, they will have a bigger share. They will have a reasonable benefit sharing. They will have a say in how those projects will be designed. And because the regulations also provide a provision on that one of the person to be included, or one of the people to be included is an NGO or an organization that tackles issues on environmental advocacy, then communities will take advantage of those organizations they trust, that they can deliver on their issues, on what they want to be included in that in those CDS. So yes, the CDA is very good as mentioned in the Act, because it gives communities a legal recognition, and it went ahead and said that where a community is registered, then the CLMC, or the Community Land Management Committee, as we call it here in Kenya, will develop the community agreements, and that gives a purely community an upper hand and a total control of how they will want their CDA to look. alternative justice resolution, or how you can tackle issues arising, which where in a case they have a registered community, then the CLMC through other community and structure and traditional structure which deals with the grievance mechanism will have to address the issue at a community level way. If they are unable to solve, then they will have to have a mediator, which involved a party that has no interest in both parties. So it's an independent body or an independent person to be an arbitrator. And it went ahead to explain that if those are not enough, then they will have to go to the environmental court, which rarely happens. And this is because if the FP process is followed due, then it's easier to solve all the problems at the early stage, because every community member will be involved, and all the issues that will be tackled during the FPIC process. And that brings us to how does FPIC will look like, how does communities envision FPIC to look like. Do we just have to go with the paper FPIC or the FPIC that someone has drafted and then we have to tick boxes, or do we have to have a community-driven FPIC? What do these communities want? How do they want to envision or see FPIC being conducted? And when we go that direction, I'm very sure that the issue of conflict or those grievances arising in the process of the project will be very minimal, because the whole process will have to tackle every issue that will be they feel like it is not okay with them, and it will be addressed at an early stage. Instead of waiting the project to kickstart, it's in the middle of implementation, and then we realize, no, this is not okay. The other thing which sometimes control or make this conflict not to happen is the impact assessment, which is also in the regulation that every project or proponent or implementer that has to implement a project in a certain community land in a certain area has to do an impact assessment or an environmental assessment in that area to be given a go-ahead to do. So during the process of that, doing the impact assessment, also it will solve problem, because if communities feel like this is our sacred place, then it will not be like, the project will not be set up there. So the impact assessment also helps in controlling these problems that arises during the project. Yeah.
So, just to summarize, she's talking about the regulation. She's spoken about how while certain safeguards are in place, it is paramount that it is actually implemented on the ground properly, that communities, even after these regulations are put in place and safeguards are put in place, do not necessarily understand what carbon markets are and what kind of agreements that they are getting into. So there is a requirement for different stakeholders to be present, to be incorporated into those legislations, so that people are aware of what is it exactly that they are getting into. The other important aspect is where the CLMC, as she's calling it, comes in, which becomes a very important part of the community land management committee, becomes a very important part of the management of the carbon credit project itself. and they are also part of the grievance redressal mechanism. So just an idea, in India we have the Community Forest Resource Management Committee under the FRA, but that's just one law and it's only dealing with forest land. We need to look at it in a more broader perspective as well. And the third interesting thing is that FPIC is not a stationary process. At any given point, if the community is uncomfortable with what is going on with the project, they can withdraw the consent. Of course, that has other implications, including costs and the communities themselves not getting the benefits out of the projects that they have involved themselves in for a very long time. But these safeguards are also important, looking at what is happening and what Jonathan spoke about. And also the fact that there is a grievance redressal system that has been put into place, with the CLMC also playing an important part in the process. So just an overview of what's happening in Kenya. Next, we also spoke to Mr. Enrique Nunes Jr., who is a member of the International Land Coalition, and he is working in the Philippines. And the Philippines has a very different context, probably more similar to the Northeast, where they do have community ownership, they have ancestral domains, and they have a very strong FPIC policy as part of the national legislature that is upgraded with every different project that comes in. So whether it is ESG related projects, whether it is carbon related projects, they have this FPIC policy, which is actually put in place by the National Indigenous Peoples Committee, which is like our Ministry of Tribal Affairs. And what we are seeing here is that the Ministry of Tribal Affairs is not involved at all in the carbon schemes. But let's take a look at what Ricky has to say. Again, apologies for a very disruptive video showing session, but I hope that some of it is getting absorbed.
Stations have been analyzed. So in response to your question, the regulatory landscape for carbon projects in the Philippines is moving really fast. It's a bit of a whirlwind, but the good news is that creating clearer rules and stricter oversight. Right now, the country is in the thick of drafting a national carbon pricing and market system. It's a complex process with a lot of cooks in the kitchen, if you try to see that. It involves multiple government agencies, civil society, indigenous peoples groups, and the private sector all at the table. So what's driving all of this activity? There are two main things. First is the international promises the Philippines has made, it has committed to. So the Philippines has committed to big emissions reduction under the Paris Agreement, and the carbon markets are the key tool to hit those targets. So the country's national determined contributions under the Paris Agreement require significant emissions reductions, pushing the government to establish mechanisms to meet those targets, including for a clear system. So right now, rules are a bit all over the place. The goal is to create one comprehensive national framework to govern everything, especially for forestry and land use projects. So the initial policy mandates, it has mandated the Climate Change Commission, the Department of Environment and Natural Resources, because they are central to the initial policy planning for the Philippines. So the goal is to move beyond existing fragmented regulations that we have and establish a more comprehensive national framework that can govern both the compliance market, if it is established, and the voluntary carbon market, particularly regarding forestry and land use. So what is actually happening on the ground? So instead of one big law, the process is unfolding through a few key documents. The Philippines is currently actively drafting an interagency consultation phase for a national carbon pricing and carbon market mechanism. Think of it as two major tracks running side by side. So the first track, this refers to the technical rules, the Department of Environment Administrative Order for Forest Carbon Projects. This is the how to guide the forest carbon projects on state-owned lands. It is all about defining the projects that are allowed and how they get approved and how they are monitored. So in a nutshell, it aims to protect the environment while giving private investors the clarity they need to get involved. And this draft policy on forest carbon credit projects will set out the comprehensive rules for establishing, managing, monitoring initiatives within state-owned lands, including forest lands, protected areas, and even national parks. And this administrative order established a dual policy foundation. First, it defines the scope and the establishment of that definition. So it defines which types of lands and which activities are included. This includes reforestation, conservation, and they're both eligible for carbon crediting. Second, as a regulator, there is regulatory compliance, so ensuring all projects adhere to national laws like the revised Forestry Code and the National Integrated Protected Area System Act that we have. And it also establishes a monitoring and verification system where the role of the Department of Environment shall oversee the technical aspects of carbon accounting and ensuring project integrity over the long term. So in essence, the proposed administrative order seeks to fill the regulatory gap by creating a clear centralized process for climate finance investment in the country, especially in the most critical natural areas, ensuring that these projects operate under the full oversight of the Department of Environment. The second important policy that we're currently working on right now would refer to FPIC, or the rights rules. So the National Commission for Indigenous Peoples are working on an amendment FPIC, and this is arguably the most critical part for communities. So a new set of rules is formalizing the process for obtaining FPIC for any project on ancestral lands, including carbon projects. So this means the rules for how to properly engage and get consent from indigenous communities are being solidified before the final market rules are even set. So these new FPIC rules provide crucial context regarding the policy status, even though they are not that about carbon-specific guidelines. So this signals that the legal framework protecting indigenous rights is solidifying, imposing strict governance on land-based projects like carbon before they even get to the financial stage. So the bottom line is, just to sum it all up, the Philippines isn't writing one final law yet. It is still in the active phase of issuing specific regulation. The two biggest pieces to watch out are the technical guidelines from the Environment Department, which refers to the forest carbon project policy, and the rights-based FPIC rules from the National Commission for Indigenous People. So it's a long effort, but the foundation is already being laid right now. It's actually fits within our broader economic development goals. So finally, the agency we really need to understand will be the National Commission for Indigenous People. So you just think of NCIP not just a participant, but as a crucial gatekeeper for any project on ancestral land. Their power comes from a land law in 1997, which is the Indigenous Peoples' Rights Act. And their primary job is to protect indigenous rights. So the NCIP ensures all projects impacting ancestral domain adhere to indigenous people's rights and the principle of free, prior, and informed consent. Many of our ancestral communities do have ancestral domain claims and ancestral domain titles. So here is what it means in practice when you talk about FPIC within the ambit of that law. So no FPIC would mean no project. It's that simple. The NCAP oversees the process of obtaining FPIC. So without their sign-off, a carbon project in an ancestral domain cannot be legally proceed. They are the shield that prevents companies from making deals that bypass the community. Second, it puts them in the driver's seats, and there's a new 2025 rules that we're working together with the NCAP, and they have been made very, very clear, and their role is even stronger. They don't just show up at the end, they're central from the beginning to the end. So in fact, agencies like the DNR now have to give an initial endorsement before the NCIP can even start the community consultation. This forces everyone to coordinate from day one. And that's always been a challenge, how to coordinate the different agencies. And third, the NCIP's oversight can be said to be forever. This is a critical new change because the NCIP job doesn't end when the first carbon credit is sold. If the project agreement changes over a period of 30 to 50 years lifespan of a carbon project, that change has to go back to the NCIP for approval. So this ensures communities have continuous protection for generations. But that new policy is still being finalized. So while the multiplicity of different departments can seem to be complex and challenging, the NCIP's powerful, clarified role is what ensures that amidst all of these technical and economic discussions, indigenous rights remain front and
so these are just some of the two examples from the global south that are trying to basically provide an overview of what carbon justice and carbon rights looks like, and just to also say that these people have been involved, these communities have been involved and have been at the government's door for several years. They've had experiences with bad carbon projects coming into the area, and it's now coming where nation states have also realized that safeguards need to be in place, and the negotiations are going on to have these policies set in place. We turn to India now to see where we stand. So we have Anjali from Landstat, who has done, who has looked at all our policies and schemes and notifications. And Anjali, if you could talk about where we stand in terms of community rights, where we stand in terms of, do we even have FPIC? What are the grievance redress mechanisms in place? What does benefit sharing look like in terms of the carbon policy that India is developing? And also if you have any idea about what kind of consultations went into putting these policies in place and how they relate to some of the other laws that we already have. So if you could just talk about that.
I'll start with the current context of Indian carbon markets, how are they evolving, the current legislation, and then move on to how we are, maybe some of the carbon justice principles, how are we looking at that, what is our take at that, and then we see how we can learn from the other countries that share their experiences, and also look at the grievance redress mechanism which exist today. So a lot of stuff is happening over the last 4 or 5 years. A lot of legislation has happened to shape up both compliance as well as the voluntary carbon markets in India. A lot of legislation. The key one is the Carbon Credit Trading Scheme (CCTS), which has been under the Energy Conservation Amendment Act 2022, and the second one is the Green Credit Program 2023. These are the two ones which have been like in the limelight and been talked about a lot. So the CCTS has both compliance mechanisms as well as an offset voluntary mechanism. The compliance mechanism is similar to a cap and trade, wherein companies who are the obligated entities like the industrial fossil fuel emitting companies, they have to stay within a capped limit to get the CCCs, the carbon credit certificates. And if they stay within the limit, they get that. So it's like a cap and trade system. And the other mechanism is the offset voluntary mechanism, which again is under the CCTS, where the government is putting in a mechanism of how voluntary carbon markets will operate. Here again, they have just recently launched the methodologies for 8 sectors, which include forestry as well as mangrove conservation and mangrove restoration. However, while they have introduced these mechanisms, there is no specific mention of who will own, who the carbon belongs to, what are the carbon rights. There is nothing specific mentioned about community benefit sharing mechanisms. There is no clarity on that. Right now they are at the methodology stage. How will it be implemented? How will communities be involved? If it's a mangrove restoration project, if it's a forest project, what is the tenure like? All of these things are not very clear right now. The second is the Green Credit Program, which came in 2023. Initially when it was launched, it was said that it would be a sort of green credits would be an incentive to do a lot of various type of environmentally positive activities, including wetland restoration and a lot of stuff. But recently, whatever has happened in 2022-24, they released a first methodology around forest mostly, how green credits will be offered to private entities who restore degraded forests by plantation. So it's completely shifted, although they said that they do a lot of activities under Green Credit Program. Currently their focus is just on plantation on degraded forests. And this too, there's interestingly there's a link between the Green Credit Program and the CAMPA, the Compensatory Afforestation Mechanism. And this was launched way back in 1980, the Forest Conservation Act. Basically, FCA required companies, polluting companies like mining and all, who were diverting land for polluting purposes to plant elsewhere, to undertake plantations elsewhere, and to sort of ease that process, they created this CAMPA fund, wherein these companies who are diverting land for polluting purposes can contribute into this fund. That was the mechanism. But now somehow they are linking the Green Credit Program with the compensatory afforestation which is happening, and they have recently introduced what is called the ACA, Accredited Compensatory Afforestation. So wherein they are saying that under accredited compensatory afforestation, companies who are diverting land can earn green credits for plantations that they are doing, and these plantations will be done by forest department. So there's a lot of gray area in the way Indian policy is shaping up. And again, they are talking about forest lands, plantation on degraded forest lands, but the way they are mentioning who the carbon credits will accrue to, they are saying carbon credits will accrue to the land owning entity. And they have specifically mentioned that these lands exclude community forest CFR lands. But however, there's a lot of contestation, a lot of land is in grey areas, because CFR titles, while they are awarded at a very slow pace. So there are a lot of claiming processes which are in the process, but because the titles have not yet been given, and all of what they are saying clearly is plantation is to happen on a degraded forest land. So what that degraded forest land means? Can it be a common forest area which is being used by the community? Can it be under contestation? Can it be under a claiming process? We don't know. So there's a lot of gray areas in the way the policy is being shaped around all of this. So this is the current situation. No clarity around carbon rights, no clarity around benefit sharing, mostly benefiting private entities and getting the carbon rights, like they're saying that they will accrue all the benefits. That's what is being said. Community is not mentioned anywhere. And so if we come to, this is the current situation. Now if we come to what kind of carbon justice principles do we have, what kind of provisions do we have which enable the practicing of these carbon justice principles, which Meena shared, mostly like what are the provisions around community tenure, what are the provisions of FPIC. So if we look at that, there are two major strong provisions around this. We have a very pluralistic tenure regime, as in the mainland India has a different way of governing forests, and the North India has a different way of governing forests. Under the mainland India, the two main provisions which sort of explicitly say that community tenure is there is the Forest Rights Act and the Panchayat extension of two Scheduled Areas Act. So under the FRA, which is the Forest Rights Act, similar to what Meenal was saying under in Kenya, the Community Forest Management Committees. Under the Forest Rights Act, communities who have been traditionally conserving and living in forested areas can claim community forest rights or individual forest rights over their forest areas. So these CFR titles ensure that communities can govern. After they get the CFR titles, they can also develop detailed CFR management plans, meaning they can develop in a very tangible way and manage their forest resources. So this in a way sort of is a very enabling provision for community tenure in India. The other is the PESA. And under the PESA, it's again a constitutional provision which was enacted in 1973 under the PESA. There are some Schedule 5 areas, which are the tribal areas, wherein the communities, the Gram Sabha, which is a village level council in the mainland India, it is given a lot of control and autonomy over how they govern their natural resources. So all the decision making around natural resources can be undertaken by the Gram Sabha. So these are in the mainland India. If we look at the northeast, Schedule 6 gives a lot of autonomy to customary village councils to manage their resources in the way they see fit. So it's mostly principles of self-determination that we see in the Philippines. So similar to that, the communities have the authority to manage their land and natural resources and take decisions about them under the Schedule 6. And to operationalize Schedule 6, we have the autonomous district councils across the northeast. I did a specific study on Meghalaya. In particular, in Meghalaya, there are Autonomous District Council Act. There are three main regions in Meghalaya: Khasi, Garo, and Jayantia. So Khasi and Jayantia Autonomous Hills District Act gives a lot of authority to the village councils to manage. But there is also a sort of like pseudo autonomous district council structure which is also there, set up by the government. But it still gives precedence to communities' way of managing their resources. And then in the Nagaland, we have the Article 371A. And under that article also, communities have a lot of discretionary power over their land and the decision making around natural resources. So these are around customary community tenure and how we have enabling provisions around that. We also have the National Working Plan Code 2023, which says that forest management plans, which are created by the Forest Department, have to consider and have to take into consideration CFR management plans. If within their forest area there is a CFR right area, if communities have been given CFR titles within their forest area, and if communities have developed a CFR management plan, then the Forest Department has to ensure that the working plan it creates takes into account the community's forest management planning process. So it's like again, the Forest Department is recognizing the community's way of managing forests and enabling the community tenure over there. Again, there is also a GFM handbook. This is not relating to community tenure, but it speaks about benefit sharing. In the GFM handbook, there is an acknowledgement that communities shall receive benefits from conservation activities, including REDD+ related activities. So that is a specific explicit mention around a carbon market mechanism. This is about enabling provisions around community tenure. If we look at FPIC processes, there are again only two strong which provide very strong safeguards: the Forest Rights Act and the PESA. Under the Forest Rights Act Section 3, communities have the Gram Sabha consent is required before any development activities or any non-forest activities take place in the community's forest area. And under the PESA Section 4, communities have authority over their natural resources and any land use decisions affecting their natural resources and their land. So these are two enabling, like directly requiring consent of communities. But however, these have been diluted over the recent years, specifically under the Van Sanrakshan Samvardhan Adhiniyam, which is the Forest Conservation Act, which was introduced in 1980s. It has now been renamed as this Van Sanrakshan Samvardhan Adhiniyam. Under this act now, consultation is required for Gram Sabhas before changing or diverting land for non-forest purposes, but not consent. So they have changed the language and diluted the FRA in itself. And Another act which sort of talks about consent is Biodiversity Act 2002. In that, there is a prior sort of again consultation required and intimation required before the of the biodiversity management committees, which are at a panchayat level, at a cluster of village level. And these biodiversity management committees sort of have the authority to take decisions in case any products from their forests are being used for commercial purposes. And they have a right to access and benefit sharing. So not so much consent, but some degree of consultation and access and benefit sharing. So these are sort of like the current status of India. If we look at grievance redressal, again, PESA and FRA have the most detailed grievance redressal, which moves from a village level to a block level to a district level to a state level, and then there is also the under the Biodiversity Act, there is the National Green Tribunal where you can dispute your cases. So that is for grievance redressal, not very, but PESA and FRA do suggest something, but not very detailed, and how much it is followed really needs to be seen. And we didn't really look at legal cases as case files as such, but just the laws. So that really needs more research. So yeah, this was the condition of like what we have in the terms of carbon justice principles. But if we were to look at how carbon markets are currently operating in India, especially the voluntary carbon markets, we sort of studied 2 carbon agreements which we could access, and we saw in those carbon agreements a lot of the carbon agreement is between a developer. So the way carbon rights are shaping up in India are through these carbon agreements. Despite all of these safeguards existing, the only real way a carbon right is usually practiced in currently is through carbon right agreements. And these carbon right agreements are between the project developer and the community or whoever is sort of implementing at the ground level, the farmers. So under this carbon rights agreement which we studied, which are existing in India only, for 2 projects, we saw that the developer sort of takes all of the decision making. What is going to be the land use, what is the duration of the project, what the farmer has to do, what the farmer does not have to do. So that carbon agreement is shaped in a way it places a lot of liabilities and a lot of restrictions on land uses for the community, and all the decision making power rests with the project developer. And if we look at benefit sharing terms, there are benefit sharing terms within the carbon development agreements, but they mostly talk about indirect benefits, like we have given you saplings or we will give you something indirect, but not what is the direct tangible benefit to the communities, any proportion of revenue, nothing is mentioned. It's just very vaguely worded things like the things they give in kind. See, okay, we helped you establish a coffee plantation by giving you saplings of trees, something like that. But nothing really tangible is mentioned in these carbon agreements. So yeah, I think this is the status where we are at. In relation to how we can maybe learn from these countries, Kenya presents a lot of similarities in the way the CLMCs are working. And because the CLMCs we can draw a parallel to the CFRMPs in India, if we can have like the CTA sort of, what is that act called? The CTA Act, right? Wherein the carbon development agreements are developed. The community development agreements. So if we have something similar to that, like the law around that, maybe we could ensure that CFRMPs get into, have the decision-making power in relation to consent, in relation to deciding the benefit sharing. If that can be sort of codified in law, then maybe we have a tangible way of seeing how carbon development agreements should be developed in India. So maybe that is something we can take from Kenya. From Philippines, I feel the consent, the FPIC process is really strong. We really need a FPIC policy. Right now, there are different legislations and they are for different areas. For example, PESA is for Schedule 5, FRA is just for tribal forest areas, Schedule 6 is Northeast, but holistically we don't have anything. So maybe we need a holistic FPIC policy at a national level to see how these projects are implemented at ground level and how FPIC should be done in stages. Currently what we have seen again in the carbon development agreements, they mention FPIC, but we have seen on the ground FPIC is just they do a meeting. इस मीटिंग में बता दिया कि कार्बन क्या है, आपको क्या मिलेगा. People don't understand. If we go back and ask them, did you, what are you doing in this project? They don't know. It's just one time meeting where they tell this project is coming, this is going to happen, and That's it. So, yeah, I think FPIC is something we really need for India. It may be something we can take from Philippines. Philippines also has a proposed bill coming up which clearly defines carbon price. Maybe we can take something from that because that is the, if that gets passed, that will be the most clear legislation around carbon price across the globe. So, I guess,
I have been told that we need to break for lunch, but you could meet us, we're here. But just as a fodder for what India needs, we do have a few questions that we have put together. What are the safeguards that we need? What would FPIC look like? Just to add, in the international forums, India repeatedly, in the multilateral agreements on environment, India repeatedly says that India does not follow FPIC. It follows public consultation processes. So this is something that, that's what India is saying internationally. Again, benefit sharing, if you're talking about benefit sharing, as you mentioned, for the agencies, that is for a very specific thing on basically genetic information from local villages. It is not carbon. So again, we need to have that specific. And we don't have a law on carbon. We have several existing laws that are being modified without consultations taking place. We have notifications that are being that are coming up under various laws, which the scheme also is part of. So we do need to demand that our government is accountable to what is going to happen on our forests and our land. Not to mention, we also have biodiversity credits that are being rolled out now. So and also, what is the grievance redressal mechanism? Even under the FRA and the PESA, under the FRA, it is specifically for claims on the land. It's not really for anything else. And also, the FRA itself does not talk about anything. It is very specific to the declaration of critical wildlife habitats. So that is again, FPIC is also a very confusing kind of structure in India, but I do agree that maybe it's time that India has a national policy on what it considers consent from communities, because we are looking at other countries doing this. Really sorry, we were hoping that this becomes a more interactive session, but we're all hungry. But please do meet us, and also this is going to be launched at the plenary, so this is all the hard work that Anjali has put in, what she was talking about. Please take a look at this, and yeah, advocate for carbon justice in India.
Thank you so much.